A landlord's racist hatred drives him to illegally evict a black family from their home. But he never expected his case would land on the desk of a Supreme Court justice. What happened next shocked everyone involved. Before we continue, don't forget to subscribe to the channel, like the video, and comment on where you're watching from. Let's get started. The rain fell in heavy sheets as Marcus Carter watched the sheriff's deputies place the last of his family's belongings on the rain-soaked lawn. His wife Janelle stood under the meager protection of a small porch overhang, arms wrapped around their two children, 10-year-old Zoe and 7-year-old Isaiah. The children's faces were streaked with tears that mingled with raindrops. 3 generations of family photos, heirloom furniture handed down from Janelle's grandmother, Isaiah's science fair trophy from last month, all of it now soaked through, some already ruined beyond repair. "Please," Marcus said, his voice barely audible above the downpour. "We just need another week. My disability check comes on Friday." Deputy Wilson avoided eye contact, clutching the eviction notice that had been served 14 days earlier. "I'm sorry, Mr. Carter, we're just doing our job." Behind the deputies stood their landlord, Richard Whitmore, a tall man in his 60s with silver hair and cold blue eyes that seemed to delight in the scene unfolding before him. He stood under a large black umbrella, his expensive loafers carefully positioned to avoid puddles. "The law is the law, Carter," Whitmore called out, not bothering to hide his satisfaction. "Should have thought about your children before you decided to stop paying rent." Marcus bit back the response that burned in his throat. He hadn't decided to stop paying rent. The construction accident that shattered his leg 3 months ago had decided for him. The same accident that left him with medical bills his insurance wouldn't fully cover, and a disability check that came too late to matter. The same accident that happened on one of Whitmore Properties' development sites, though Richard Whitmore had made sure his company bore no responsibility. "We paid rent for 2 years without missing a single payment," Janelle said, stepping forward, her voice shaking with a mixture of rage and desperation. 3 months. We just needed 3 months. Whitmore's thin lips curved into what might have been a smile on another face. "Business is business, Mrs. Carter. Besides," he added, lowering his voice so only those closest could hear, "your kind always thinks the rules don't apply. Time you learned differently." Janelle stiffened, pulling her children closer. Marcus saw her shoulders tense, recognized the subtle shift in her posture that meant she was about to respond in a way that might make things worse. He moved to her side, placed a gentle hand on her arm. "Not now," he whispered. "Not in front of the kids." A clap of thunder punctuated his words, making Isaiah whimper. The boy clutched his mother tighter, his Spider-Man backpack, the only possession he'd insisted on carrying himself, already darkened with rain. "You have until sundown to remove your belongings from the property," Deputy Wilson said, his professional tone doing little to mask his discomfort. "Anything left will be considered abandoned." Marcus nodded, not trusting himself to speak. The deputies retreated to their vehicles, leaving the Carters alone with Whitmore on what had been their front lawn for the past 2 years. "I'll have the locks changed within the hour," Whitmore said, turning to leave. He paused, glancing back at their possessions strewn across the grass. "Though I doubt there's much worth salvaging now." As Whitmore walked to his luxury sedan parked at the curb, Marcus heard his phone ring. The landlord answered it with an immediate change in demeanor, his voice shifting to a syrupy politeness that Marcus had never heard directed at his family. "Yes, Councilman Davis. Of course I can attend the fundraiser. I'd be honored. Yes, I've always supported your vision for the city." Marcus watched him drive away, the expensive car splashing through puddles that further soaked their belongings. Only when the taillights disappeared around the corner did he allow his shoulders to slump. "What do we do now?" Zoe asked, her voice small but determined not to break. At 10, she was already trying to be strong for her younger brother, a reality that broke Marcus's heart anew. Before either parent could answer, a car pulled up to the curb. For a moment, Marcus tensed, thinking Whitmore had returned. Instead, a middle-aged black woman emerged, hurrying toward them with an umbrella. "Janelle? Marcus? Oh my Lord." It was Deborah Washington, Janelle's co-worker from the hospital where she worked as a nurse's aide. "I came as soon as I got your message." Deborah took in the scene: the rain-soaked furniture, the shell-shocked family, the eviction notice still clutched in Marcus's hand. Her face hardened with an emotion Marcus recognized all too well. The particular anger reserved for injustices that were both expected and still somehow shocking. "My sister's got a 2-bedroom apartment over in Oakwood," she said, already guiding Zoe and Isaiah toward her car. "She's away visiting her daughter in Atlanta for the next month. You all can stay there until you figure things out." "Deborah, we can't," Janelle began. "You can and you will," Deborah cut her off. "Now let's get these babies out of the rain. Then we'll come back for whatever we can salvage." 2 hours later, they had managed to rescue what they could. The apartment was small but clean, with a pull-out couch in the living room where Marcus and Janelle would sleep. The children took the second bedroom, their few salvaged toys already arranged in careful rows by Isaiah, who seemed to find comfort in the organization. While the children settled in, the adults gathered in the small kitchen. Deborah placed 3 mugs of hot coffee on the table. "That man has been trying to push every black family out of that neighborhood for years," Deborah said, her voice low to keep from being overheard by the children. "My cousin rented from him back in 2018. Same story, 1 late payment, and he was serving eviction notices. We tried to reason with him," Marcus said, staring into his coffee. "Offered to pay extra once I got back on my feet. He wouldn't even consider it." "The worst part is he's breaking the law," Janelle added, her nurse's training showing in the precise way she tore open a sugar packet. "I looked it up. The city has COVID eviction protections still in place for cases of medical hardship. When I showed him the ordinance, he laughed and said his lawyer would take care of it." "And did you talk to a lawyer?" Deborah asked. Marcus and Janelle exchanged glances. "We called the legal aid office," Marcus admitted. "They're overwhelmed with cases. Said they'd get back to us in a few weeks." "A few weeks," Deborah repeated flatly. "And in the meantime, you're out on the street in the pouring rain." Janelle's phone buzzed with a text message. She glanced at it, then passed it to Marcus without a word. It was from their neighbor, Mrs. Henderson, an elderly woman who had lived next door to them and had often watched the children when both Marcus and Janelle had to work. The message included a photo of Whitmore showing their former home to a young white couple, gesturing expansively as he led them inside. The timestamp showed it had been taken less than an hour ago. "He already has new tenants lined up," Marcus said, his voice hollow. "We're not even gone a day. And I bet they're not paying the $300 more in rent that he wanted from us to renew the lease," Janelle added bitterly. Deborah's expression shifted, a look of determination settling over her features. "My daughter's roommate from college is in law school now. Works at that new civil rights clinic downtown. Let me call her." Before either of them could respond, there was a small voice from the doorway. "Dad? Can you tuck me in?" Isaiah stood there in his Batman pajamas, the ones Marcus had managed to grab from the dryer before they left. His small face was tight with the effort of not crying, of being brave for his parents. "Of course, buddy," Marcus said, forcing a smile. "Let me tell you a story about a brave knight who protected his family from the storm." Later, with both children finally asleep, Marcus sat alone in the darkened living room. Janelle had collapsed into exhausted sleep on the pull-out couch, but rest eluded him. His injured leg throbbed, a persistent reminder of how quickly their lives had unraveled. He pulled out his phone and opened the browser, typing "housing discrimination lawsuit" into the search bar. Most of the results were legal websites with complex terminology that swam before his tired eyes. But one link caught his attention: a news article about Supreme Court Justice Elijah Freeman's recent speech at Howard University Law School. The article quoted Freeman, the court's second black justice. Housing discrimination remains one of the most pervasive yet under-litigated civil rights issues in America today. The laws exist to protect citizens, but without enforcement, they are merely words on paper. Marcus read the article twice, then bookmarked it. Supreme Court justices were far removed from the problems of ordinary people like him. Justice Freeman probably had no idea what it felt like to watch your children's belongings thrown onto a rain-soaked lawn, to see the barely concealed satisfaction in a landlord's eyes as he destroyed your family's security. Still, there was something about Freeman's words that kindled a small flame of resolve within Marcus. He didn't know much about the law, but he knew what was right. And what had happened to his family today was wrong. His phone buzzed with a text from Deborah. Maya, daughter's roommate, says come to the Civil Rights Clinic tomorrow at 9 a.m. Bring all paperwork. Her professor wants to hear your story. Marcus stared at the message for a long moment, then texted back a simple, "Thank you. We'll be there." Outside, the rain had finally stopped. In the quiet apartment, with his family finally safe for the moment, Marcus made a silent promise. This wasn't over. Richard Whitmore had chosen the wrong family to target. Marcus didn't know how yet, but somehow he would find a way to fight back, not just for his family, but for every family that Whitmore had forced from their homes. What he couldn't know was that the small civil rights clinic they would visit tomorrow had a direct connection to Justice Elijah Freeman, or that their case would soon land on the desk of the very Supreme Court justice, whose words had given him hope in his darkest hour. The Howard University Law School Civil Rights Clinic occupied the third floor of a renovated brownstone on the edge of campus. The waiting area was modest but dignified, with framed photographs of civil rights pioneers lining the walls. Thurgood Marshall's determined gaze watched over a worn but comfortable seating area where Marcus and Janelle sat nervously the next morning, a folder of documents clutched in Marcus's hands. Zoe and Isaiah were with Deborah, who had taken the day off work to help. Marcus was grateful. The children had been through enough trauma without sitting through hours of legal discussions about their eviction. "Do you think they can really help us?" Janelle whispered, smoothing non-existent wrinkles from her skirt. She had worn her best outfit, the one she usually saved for church, as if dressing formally might somehow improve their chances. Before Marcus could answer, a young woman with natural hair pulled back in a neat puff approached them. She wore a crisp blazer over jeans, an ID badge clipped to her lapel identifying her as Maya Jenkins, student attorney. "Mr. and Mrs. Carter, I'm Maya, Deborah's daughter's friend." Her handshake was firm, her smile genuine. "Thank you for coming in. Professor Wilkins is eager to meet you." She led them down a hallway lined with more photographs, these showing the clinic's past victories, Marcus realized. Newspaper clippings and court documents, all framed like trophies. "The clinic takes on about 20 cases per semester," Maya explained as they walked. "We focus on housing discrimination, voter suppression, and police misconduct. Professor Wilkins supervises all our work, but we students handle much of the day-to-day." She paused outside a door, lowering her voice. "I should mention, Professor Wilkins can be intense. Don't let it intimidate you. She just feels these injustices personally." Before either Carter could respond, Maya knocked and opened the door to a corner office. Windows on 2 walls filled the space with natural light, illuminating bookshelves packed with legal volumes and more framed photographs, these more personal than those in the hallway. Behind a desk covered with organized stacks of papers sat an imposing woman in her 50s. Professor Alexandria Wilkins had the kind of presence that commanded attention without effort. Back straight, eyes sharp behind stylish glasses, silver locks pulled back in an elegant updo. "Mr. and Mrs. Carter, please come in," she said, rising to shake their hands. "I'm Alexandria Wilkins. I understand from Maya that you've experienced what appears to be discriminatory eviction practices." As they sat in the chairs across from her desk, Marcus noticed a framed photograph behind the professor. It showed a much younger Wilkins standing beside a man he recognized from his late-night research. Justice Elijah Freeman, though in the photo he was decades younger, both of them in graduation robes. Professor Wilkins followed his gaze. "Justice Freeman and I were classmates," she said with a small smile. "Back when we were both idealistic enough to believe we could change the world through law alone." The smile faded. "Now, tell me about your situation." For the next 20 minutes, Marcus and Janelle took turns explaining their story. The accident, the missed rent payments, the refused extensions, and finally, yesterday's eviction. Marcus described Whitmore's comments, the pattern of behavior Deborah had mentioned, and the apparent violation of the city's COVID eviction protections. Professor Wilkins listened without interruption, taking occasional notes. Only the tightening of her jaw revealed her emotional response to their story. "And you have documentation?" she asked when they finished. "Lease agreements, medical records, evidence of the hardship request?" Marcus handed over the folder he'd been clutching. "Everything we could save. Some of our paperwork was damaged in the rain yesterday." Wilkins nodded, beginning to sift through the documents with practiced efficiency. After a few minutes, she looked up. "Mr. Carter, Mrs. Carter, what Richard Whitmore did to your family appears to be not only morally reprehensible, but legally actionable on multiple fronts. The pattern of behavior suggests racial discrimination under the Fair Housing Act. The denial of hardship extension violates our city's COVID protections, and the manner of eviction itself may constitute constructive eviction, which is illegal in this jurisdiction." She removed her glasses, fixing them with an intent gaze. "I believe the Civil Rights Clinic can help you, but I want to be clear about what that means. Legal actions take time. We can file for emergency relief to potentially get you back into your home, but the larger case against Whitmore could take months, even years." "We understand," Janelle said, reaching for Marcus's hand. "But this isn't just about us anymore. If he's done this to other families—" "Exactly." Wilkins nodded approvingly. "This case has potential beyond your individual situation. If we can prove a pattern of discriminatory evictions, we could create precedent that protects thousands of families." Marcus felt a weight simultaneously lifting from his shoulders and settling in his chest. Relief that they might get justice, anxiety about the long road ahead. "What do we need to do?" he asked. "For today, sign these forms authorizing us to represent you." Wilkins slid several documents across the desk. "Maya will be your primary contact, but I'll be supervising her work closely. This case—" She paused, something hardening in her expression. "This case matters to me personally." As they completed the paperwork, Maya returned with a tablet. "Professor, I've pulled the property records for all of Whitmore's holdings. It's worse than we thought. In the past 5 years, he's evicted 23 black families, compared to only 2 white families. And the black families had an average of 2.7 late payments before eviction, while the white families averaged 6.5. Wilkins's expression didn't change, but her voice took on a steely quality. "Add that to the case file, and contact the previous tenants. We need affidavits from as many as possible." She turned back to the Carters. "We'll file for emergency relief this afternoon. With luck, a judge might hear us by next week. In the meantime, do you have stable housing?" "Temporarily," Marcus answered, explaining about Deborah's sister's apartment. Wilkins nodded. "Maya, connect them with our housing assistance network. We need something more permanent, just in case." As they prepared to leave, Wilkins held out a business card with her personal cell number handwritten on the back. "Call me directly if anything changes. And Mr. Carter," her voice softened slightly, "what happened to your family was wrong. The law is on your side, even when it feels like nothing else is." In the hallway outside, Maya walked them through next steps. "Professor Wilkins doesn't usually take such a hands-on approach with new cases," she commented. "She must see something special in yours." "Is it because of the connection to Justice Freeman?" Marcus asked, gesturing toward the photograph he'd noticed. Maya hesitated. "They've remained close, yes. But it's more than that. The professor has been tracking Whitmore properties for years. Your case might be the one that finally lets her take action against their practices." As they stepped outside into the bright morning, Marcus felt the first stirrings of hope since the accident that had upended their lives. The legal system that had seemed so distant, so inaccessible yesterday, suddenly had faces and voices attached to it. Maya's earnest determination, Professor Wilkins's controlled anger. "Do you think we can really win?" Janelle asked as they walked toward the bus stop. Marcus thought about Whitmore's smug expression in the rain, about Isaiah's tears, about the countless other families who had faced similar injustices without the benefit of a civil rights clinic to fight for them. "I don't know," he answered honestly. "But for the first time since this started, I think we have a chance." What neither of them knew was that across town, Richard Whitmore was meeting with his own legal team, a high-powered firm whose senior partner had gone to prep school with him decades ago. The eviction of the Carter family was just one small move in a much larger strategy, one that had been unfolding for years with careful precision. And what Professor Wilkins hadn't shared was that her interest in Whitmore properties went beyond professional concern. 15 years earlier, her own parents had been forced from their home by Richard Whitmore's father, using the same tactics now employed by the son. She had been a law student then, powerless to help. She had vowed never to be powerless again. As Maya had said, this case was special. But none of them yet understood just how far its implications would reach, or that it would eventually land on the desk of the second most powerful jurist in the nation, a man who knew all too well what it meant to fight for one's home. The emergency relief hearing was scheduled for the following Tuesday before Judge Raymond Patel in the district court. The intervening days passed in a blur for the Carters. Maya had been true to her word, connecting them with the clinic's housing network, which helped them secure a modest 2-bedroom apartment with a 6-month lease. The rent was subsidized through a non-profit partner of the clinic, making it affordable even on their reduced income. Zoe and Isaiah had been enrolled in schools in their new district, another miracle Maya had somehow managed to expedite. The children were resilient, but Marcus could see the toll the upheaval had taken. Isaiah had started sleeping with his Spider-Man backpack, as if afraid his remaining possessions might disappear in the night. Zoe had grown quieter, her usual exuberance dimmed, though she diligently helped unpack their salvaged belongings in the new apartment. The morning of the hearing, Marcus dressed in his only suit, thankfully spared from the rain by having been at the dry cleaner during the eviction. His injured leg throbbed as he navigated the courthouse steps, Janelle steady at his side. Professor Wilkins met them in the lobby, her professional demeanor a stark contrast to the chaos Marcus felt inside. She wore a tailored charcoal suit, her silver locks arranged in an elegant updo that projected both authority and grace. "The goal today is simple," she explained as they walked toward the courtroom. "We're asking Judge Patel to grant an injunction allowing you to return to your home while the broader discrimination case proceeds. We have 3 strong arguments: the violation of COVID eviction protections, evidence of disparate treatment based on race, and the improper execution of the eviction itself." "What are our chances?" Janelle asked, gripping Marcus's hand tightly. Wilkins's expression remained carefully neutral. "Judge Patel is fair, But he's also cautious. Whitmore's attorneys will argue that returning you to the property would cause their client economic harm, especially if he's already placed new tenants. He showed the house the same day we were evicted, Marcus said, his jaw tightening at the memory of the photograph their neighbor had sent. Which works in our favor, Wilkins nodded. It suggests premeditation and bad faith. Just remember, stay calm, answer only what's asked, and let me handle the legal arguments. As they approached the courtroom doors, Maya hurried toward them, slightly out of breath. "Professor, you need to see this." She handed Wilkins a tablet, pointing to something on the screen. Wilkins's expression hardened as she read. "When did this happen?" "It posted 20 minutes ago," Maya replied. "It's already getting traction online." Wilkins turned to the Carters, her voice level but with an undercurrent of contained fury. "Richard Whitmore has given an interview to City Business Journal. He's framing your eviction as part of his company's neighborhood improvement initiative. He claims the company is raising standards in what he calls underperforming areas." Marcus felt his blood pressure rising. "That's code for pushing black families out." "Exactly," Wilkins agreed. "He's also specifically mentioned your family, claiming you had a history of late payments and property damage beyond the recent missed rent." "That's a lie." Janelle's voice rose sharply. "We never missed a payment before Marcus's accident, and we left that house in perfect condition until they threw our belongings into the rain." Wilkins nodded. "We know. And this kind of public character assassination gives us another avenue for damages. For now, let's focus on today's hearing. Maya, prepare a statement refuting these claims for after court." Inside the courtroom, Marcus immediately spotted Richard Whitmore seated at the respondent's table. He was flanked by 3 attorneys in expensive suits, all from Johnson, Pritchard & Wells, one of the city's most prestigious firms, according to the business cards they had presented to Professor Wilkins. Whitmore didn't acknowledge the Carters' presence, but Marcus caught the slight smirk that crossed his face when he noticed Marcus's limp. The landlord leaned over to whisper something to his lead counsel, an older man with steel-gray hair and a tailored suit that probably cost more than 3 months of the Carters' rent. Judge Patel entered, a man in his 60s with a reputation for strict adherence to procedure. The proceedings began with Wilkins presenting their emergency motion, outlining the violations of city ordinances and evidence of discriminatory intent. "Your Honor, the Carters suffered not only an illegal eviction during a protected period of medical hardship, but were targeted due to their race, as part of a documented pattern of discriminatory practices by Whitmore Properties," Wilkins argued, her voice filling the courtroom with calm authority. When Whitmore's attorney, Bradford Pritchard, rose to respond, his approach was immediate and aggressive. "Your Honor, this is a straightforward case of non-payment. The Carters failed to meet their contractual obligations for 3 consecutive months. The supposed hardship extension they claim entitlement to requires documentation they never provided. As for the alleged discrimination, my client has an impeccable reputation as one of this city's premier developers. These inflammatory accusations are merely an attempt to avoid the consequences of their financial irresponsibility." Judge Patel interrupted. "Mr. Pritchard, the COVID ordinance explicitly states that medical hardship extensions must be granted when requested with supporting documentation. Did Mr. and Mrs. Carter provide such documentation?" Pritchard hesitated, just long enough for Wilkins to notice. "They submitted some paperwork, Your Honor, but it was incomplete and insufficient." "I have copies of all submitted documentation," Wilkins countered, sliding a folder across to the judge, "including medical records, proof of disability claim filing, and their formal request for extension, all delivered to Whitmore Properties 6 weeks before the eviction." The hearing continued for nearly 2 hours, with both sides presenting arguments. When Marcus was called to testify, he felt a momentary panic, but Professor Wilkins's steady gaze calmed him. He described the accident, the financial hardship, and their attempts to work with Whitmore. When Pritchard cross-examined him, the attorney's tone was dismissive. "Mr. Carter, isn't it true that you've had multiple confrontations with Mr. Whitmore prior to this eviction?" Marcus blinked in confusion. "No, sir. I've only spoken to him a handful of times, mostly about maintenance requests." "And didn't you threaten him when he first mentioned the possibility of eviction?" "Objection." Wilkins stood. "Counsel is mischaracterizing the record. There's no evidence of any threat." "Sustained," Judge Patel agreed. "Mr. Pritchard, confine your questions to facts and evidence." By the time Whitmore himself took the stand, Marcus could see the strategy: paint him as an angry, intimidating presence, and Whitmore as a businessman simply protecting his investments. The landlord played his part perfectly, speaking in measured tones about difficult decisions and maintaining community standards. It was only when Wilkins cross-examined him that cracks appeared in his facade. "Mr. Whitmore, you stated earlier that the Carters had a history of late payments. Can you identify any late payment prior to Mr. Carter's accident?" Whitmore shifted in his seat. "Not specifically, no. My property manager handles the day-to-day records." "Your property manager who isn't here today," Wilkins noted. "Mr. Whitmore, did you tell the Carters, and I quote, 'Your kind always thinks the rules don't apply'?" "Objection." Pritchard was on his feet. "Hearsay." "Your Honor, this goes directly to discriminatory intent," Wilkins countered. "I'll allow it," Judge Patel decided. "The witness will answer." Whitmore's jaw tightened. "I don't recall making any such statement." "You don't recall," Wilkins repeated. "Just as you don't recall receiving the Carters' hardship documentation, despite the certified mail receipt with your signature that we've entered into evidence." As the hearing concluded, Judge Patel announced he would take the matter under advisement and issue his ruling within 48 hours. Outside the courtroom, reporters had gathered. News of Whitmore's interview had spread, and the case was attracting attention. Professor Wilkins deftly handled the press, with Marcus and Janelle standing silently beside her as she refuted Whitmore's claims and outlined the legal issues at stake. Across the courthouse steps, Whitmore was giving his own statement, his attorneys flanking him protectively. "How do you think it went?" Marcus asked Wilkins quietly as they walked toward her car. "Judge Patel is deliberate but fair," she replied. "Whitmore's story had inconsistencies that didn't escape notice. I'm cautiously optimistic." She paused, checking her phone. "In the meantime, I've been authorized to pursue a broader class action. Maya has identified 14 other families with similar experiences with Whitmore properties in the past 2 years alone." Later that evening, as Marcus helped Isaiah with homework in their new apartment, his phone rang with a number he didn't recognize. "Mr. Carter? This is Alexandria Wilkins. I've just received word from a clerk at the court. Judge Patel will rule in our favor tomorrow morning." Marcus nearly dropped the phone. "We won?" "The emergency injunction, yes. It's just the first step, but it means Whitmore will be ordered to allow your family to return to your home. The broader discrimination case will proceed separately." After ending the call, Marcus sat in stunned silence until Janelle noticed his expression. "What is it? What's wrong?" she asked, alarm edging into her voice. "Nothing's wrong," he said, a smile slowly spreading across his face. "We're going home." What he couldn't know was that across town, Richard Whitmore was already planning his next move, one that would elevate this case far beyond a simple landlord-tenant dispute and eventually bring it to the attention of the highest court in the land. The morning Judge Patel issued his official ruling should have been a triumph for the Carter family. Instead, they arrived at their former home accompanied by Professor Wilkins and a court officer to find the locks changed, not once, but twice, and a no trespassing sign prominently displayed on the front door. More shocking was the state of the interior, visible through the windows. Walls had been stripped to the studs, flooring torn up, and fixtures removed. "He's gutted it," Marcus said in disbelief, peering through the living room window. "The entire house is demolished inside." The court officer, a middle-aged woman who had introduced herself as Officer Chen, documented everything with her department-issued camera. "This appears to be in direct violation of Judge Patel's order," she noted, her voice professional but tinged with disgust. The ruling specifically stated the property was to be maintained in its prior condition. Professor Wilkins's expression remained calm, but her eyes betrayed a cold fury as she made phone calls, first to Judge Patel's chambers, then to Maya at the clinic, and finally to local news outlets. "This is no longer just contempt of court," she told the Carters as they stood on the sidewalk. "This is destruction of evidence." Within an hour, the quiet street had transformed into a media circus. News vans lined the curb, reporters with microphones jockeyed for position, and curious neighbors gathered at a distance. Richard Whitmore was conspicuously absent, but his attorney Bradford Pritchard arrived in a black SUV, his face a mask of professional concern, as he surveyed the scene. "My client was under the impression that renovations could proceed," he told a cluster of reporters, his voice pitched to Carrie. "This appears to be an unfortunate misunderstanding of Judge Patel's order." "Misunderstanding," Wilkins countered when a microphone was thrust in her direction. "The order explicitly prohibited any alteration of the property pending resolution of this case. What we're seeing is a deliberate attempt to render the property uninhabitable and destroy evidence of housing discrimination." By mid-afternoon, Judge Patel had issued an emergency amendment to his ruling, finding Richard Whitmore in contempt of court and imposing a substantial daily fine until the matter was resolved. More significantly, he ordered Whitmore Properties to provide comparable housing for the Carter family at the company's expense, along with storage for their belongings. "It's not the victory we wanted," Wilkins admitted as they left the courthouse after the emergency hearing. "But it's actually better for our larger case. Whitmore has now demonstrated a pattern of willful disregard for court orders, which strengthens our discrimination claims." Janelle, who had been quiet throughout the proceedings, finally spoke. "I don't want to live in anything he owns. I don't trust him." Wilkins nodded, understanding. "The judge's order gives us leverage to negotiate a cash settlement for immediate housing needs instead. We can argue that given Whitmore's actions, direct housing from his company represents an undue burden and potential safety risk." That evening, as the story led local newscasts, the Carters gathered in their temporary apartment. The children had been shielded from the day's events, but they sensed the tension in their parents' faces. "Are we going back to our old house?" Isaiah asked as Marcus tucked him into bed. Marcus hesitated, searching for words that wouldn't frighten his son. "Not right away, buddy. The house needs some repairs first." "Because of the rain on our stuff?" Isaiah's innocent question tightened Marcus's chest. "Something like that," he managed. "But we're going to find an even better place, I promise." After the children were asleep, Marcus and Janelle sat at their small kitchen table, speaking in hushed tones. "I never thought he'd go this far," Janelle said, her hands wrapped around a mug of tea. "Destroying his own property just to keep us out?" "It's not about the property," Marcus replied, the day's events crystallizing something he'd felt since the eviction. "It's about power, control. He couldn't stand losing in court, having someone tell him he couldn't do whatever he wanted to us." "Professor Wilkins says this helps our case," Janelle said, though uncertainty clouded her voice. "Maybe, but it also shows how dangerous he is." Marcus rubbed his throbbing leg, a habit he'd developed since the accident. "I just want our kids to feel safe again." The next morning brought another development. Maya arrived at their apartment with news that made the previous day's events seem almost minor by comparison. Whitmore Properties has filed an appeal challenging the constitutionality of the city's COVID eviction protections, she explained, spreading legal documents across their table. They're claiming the ordinance represents an unconstitutional taking of private property without just compensation. What does that mean for us? Marcus asked, scanning the dense legal text without comprehension. It means they're trying to escalate this beyond our case, Professor Wilkins explained, having arrived moments after Maya. They're challenging the legal foundation of tenant protections across the entire city. Can they do that? Janelle asked. They can try, Wilkins replied, her voice hardening. In fact, I suspected something like this might happen. The Johnson Pritchard firm has been looking for a case to challenge these protections since they were enacted. Your situation gives them the perfect vehicle. Over the next few weeks, the legal battle intensified. While the Carters moved into a new apartment, secured with help from the housing network and funded by a preliminary damages payment Wilkins had negotiated, the case began to attract national attention. Housing rights organizations filed amicus briefs supporting the city's ordinance. Property owners' associations backed Whitmore. The case transformed from a single family's fight against an unjust eviction into a battleground over the limits of government power to protect vulnerable tenants during a crisis. The appeals court expedited the case, recognizing its significance. Arguments were scheduled for late October, just 6 weeks after the initial eviction. In the meantime, the Civil Rights Clinic continued building their discrimination case, gathering affidavits from other former Whitmore tenants and analyzing years of eviction data. What's remarkable, Maya told Marcus during a preparation session for his testimony, is how blatant the pattern is once you see the data. Black tenants were 3 times more likely to be evicted than white tenants with identical payment histories, and the language in internal company emails. She shook her head, still shocked by what they'd discovered through discovery motions. They actually categorized neighborhoods by demographic codes. Areas with higher black populations were labeled transitional or upgrade targets. Marcus had grown more confident as the case progressed, learning the legal terminology, understanding the strategies. But as the appeals court date approached, he found himself increasingly concerned about the broader implications. What happens if we lose? He asked Professor Wilkins after a particularly intense preparation session. Not just for us, but for everyone protected by these ordinances? Wilkins considered her answer carefully. If the appeals court strikes down the ordinance, thousands of families could face eviction. But that's not going to happen. How can you be so sure? Because we have the law and the facts on our side, she replied. And because I've already prepared our Supreme Court petition, just in case. Supreme Court? Marcus echoed, the possibility both thrilling and terrifying. You think it could go that far? Whitmore's attorneys are banking on it, Wilkins said. They've brought in constitutional law specialists. This isn't just about your apartment anymore. It's about establishing a precedent that could affect housing rights nationwide. The media attention intensified as the appeals court date approached. The Carters tried to maintain a normal life for their children, but it became increasingly difficult as reporters sought interviews and camera crews appeared outside their new apartment. Professor Wilkins helped them navigate the attention, coaching them on which questions to answer and which to deflect. Your story matters, she told them, but you control how much of it you share. The day before the appeals court hearing, Janelle returned from picking up the children at school, her face tight with anger. What happened? Marcus asked, recognizing her expression immediately. Isaiah's teacher pulled me aside, she said, her voice shaking slightly. Apparently, a man came to the school office today, claiming to be conducting background checks for financial reasons. He was asking questions about us, our parenting, if Isaiah had behavioral issues, whether we'd ever been reported to child services. Whitmore, Marcus said, the name itself now enough to raise his blood pressure. Has to be. Janelle agreed. The principal recognized him from the news and refused to answer his questions, but the fact that he would go to our children's school. That night, after reporting the incident to Professor Wilkins and the police, Marcus lay awake long after Janelle had fallen into restless sleep. Tomorrow they would face Whitmore again in court, this time with much higher stakes. What had started as a fight for their home had become something far larger, a battle over the rights of tenants everywhere, the limits of government protection, and the persistent reality of housing discrimination. And somewhere in Washington, D.C., though Marcus didn't know it yet, Supreme Court Justice Elijah Freeman had already taken notice of the case that bore his former classmate's name on the briefings: Whitmore Properties versus Carter. The Fifth Circuit Court of Appeals occupied a stately limestone building downtown, its columned entrance designed to inspire reverence for the law. As Marcus and Janelle climbed the steps, accompanied by Professor Wilkins and Maya, they were met by a crowd of supporters organized by housing rights activists. People held signs reading, "Housing is a human right," and "Stop racist evictions." Many were families who had faced similar situations, their presence a powerful reminder that the Carters' fight had become emblematic of a larger struggle. Inside the ornate courtroom, the atmosphere was tense. The three-judge panel, Judges Hernandez, Clarkson, and Mitchell, watched impassively as attorneys prepared their arguments. Richard Whitmore sat with an expanded legal team, now including nationally recognized constitutional law expert Leonard Drake, known for arguing landmark property rights cases before the Supreme Court. Professor Wilkins had prepared the Carters for this escalation. Drake's presence confirms their planning for this to go all the way to the Supreme Court, she had explained during their preparation session. His specialty is challenging government regulations on private property. The appeal focused not on the Carters' specific situation, but on the broader question of whether the city's COVID eviction protections constituted an unconstitutional taking under the Fifth Amendment. Whitmore's team argued that forcing landlords to continue housing non-paying tenants, even temporarily, deprived them of property rights without just compensation. Leonard Drake presented the argument with practiced eloquence. "Your Honors, the city's ordinance, however well-intentioned, forces private property owners to bear a public burden that should rightfully be shared by all taxpayers. If the city wishes to provide housing assistance during hardship, it should do so through public funds, not by conscripting private property." Judge Clarkson, known for his conservative leanings, nodded slightly as Drake spoke. Judge Hernandez remained inscrutable, while Judge Mitchell frowned, leaning forward with a question. "Counsel, wouldn't your argument effectively invalidate most tenant protection laws? After all, many such protections temporarily restrict a property owner's rights for public policy reasons." Drake smiled slightly, as if he'd anticipated the question. "Not at all, Your Honor. Traditional tenant protections govern the terms of voluntary contracts. This ordinance goes much further, essentially forcing landlords to provide free housing services after the contractual relationship has been breached." When Professor Wilkins rose to respond, her approach was methodical. She addressed not only the constitutional questions, but connected them back to the specific circumstances of the Carter case, emphasizing the evidence of discriminatory intent. "Your Honors, this appeal attempts to obscure what is fundamentally a case about the discriminatory application of eviction practices. The city's ordinance is narrowly tailored to address a specific crisis, with provisions for landlord hardship exemptions that Mr. Whitmore never sought." Her voice remained steady as she continued. "More significantly, the record shows clear evidence of racial animus in Mr. Whitmore's eviction practices, a pattern that extends well beyond the Carter family." Judge Hernandez interrupted. "Counselor, while those allegations are concerning, this appeal focuses on the constitutionality of the ordinance itself. Are you arguing that evidence of discrimination somehow affects the takings analysis?" "Yes, Your Honor, I am," Wilkins replied without hesitation. The Supreme Court has consistently held that constitutional analyses cannot be divorced from the context in which they arise. Here, the evidence suggests Mr. Whitmore is not seeking to vindicate constitutional principles, but to avoid accountability for discriminatory housing practices. For 2 hours, the arguments continued, with judges probing both sides with increasingly technical questions. Marcus, watching from his seat behind the plaintiff's table, was struck by how abstract the discussion had become, how his family's trauma had been transformed into constitutional theory and precedent citations. During a brief recess, he whispered to Janelle, "It's like they've forgotten this is about actual people losing their homes." She squeezed his hand. "Professor Wilkins hasn't forgotten. Look at her notes. Our names are at the top of every page." When the hearing concluded, Judge Hernandez announced they would take the matter under advisement, with a ruling expected within weeks. Outside, reporters swarmed both legal teams. "Professor Wilkins, if you lose here, will you appeal to the Supreme Court?" a journalist called out. "We're confident in our position," Wilkins replied diplomatically, "but we're prepared for every contingency." Across the courthouse steps, Leonard Drake was more direct with his own cluster of reporters. This case raises fundamental questions about property rights that ultimately need Supreme Court resolution. We believe the Fifth Circuit will recognize the constitutional infirmities in this ordinance, but either way, this is just one step in the process. Later that evening, as the Carters debriefed with their legal team at the clinic, Maya showed them social media coverage of the hearing. "The case is trending nationally," she explained. "Housing rights organizations across the country are watching." Professor Wilkins's phone rang, a Washington, D.C. number. She excused herself to take the call in her office, returning 15 minutes later with a carefully neutral expression that nevertheless couldn't quite hide her excitement. "That was a clerk from Justice Freeman's chambers," she said once the door was closed. "He's following the case." 500 miles away in Washington, D.C., Supreme Court Justice Elijah Freeman sat in his chambers, reviewing the preliminary briefings in Whitmore Properties v. Carter. Though the case hadn't officially reached the court, his former classmate Alexandria Wilkins had made sure he received the key documents through appropriate channels. At 62, Justice Freeman had served on the nation's highest court for 8 years, appointed after a distinguished career as a civil rights attorney and later as a federal judge. Known for his incisive questioning during oral arguments and his meticulously researched opinions, he had become one of the court's most respected voices, particularly on issues of racial justice and equal protection. The Carter case interested him on multiple levels. Legally, it presented important questions about the balance between property rights and government authority during crises. But it was the underlying discrimination claims that had initially caught his attention. "Justice Freeman?" His clerk, Aisha Johnson, knocked softly on the open door. "I've compiled those housing discrimination statistics you requested." Freeman looked up from the briefing, gesturing for her to enter. "Thank you. Anything surprising?" "Not surprising, but concerning," Aisha replied, placing a folder on his desk. During the pandemic, eviction rates for black tenants were 2.3 times higher than for white tenants nationally, even controlling for income and payment history. In the jurisdiction where the Carter case originated, the disparity was 3.1 times. Freeman nodded grimly. "And landlords like Whitmore know they can usually get away with it because most victims lack the resources to fight back." He tapped the briefing. "What makes this case unusual is the legal representation and the documented pattern of behavior." "Do you think the court will take it if it comes to us?" Aisha asked. "Almost certainly," Freeman replied. "The property rights question alone would attract at least 4 votes for certiorari. Add the equal protection dimension, and it becomes the kind of case that could define our term." He paused, his expression thoughtful. "Alexandria Wilkins is one of the sharpest legal minds I know. If she's leading this fight, There's more here than meets the eye." The justice turned to his window, looking out at the Capitol dome illuminated against the evening sky. Decades earlier, he had experienced housing discrimination firsthand. A young law professor denied an apartment rental in a predominantly white neighborhood, despite impeccable qualifications. That experience had shaped much of his subsequent legal career. "Pull the amicus briefs as they come in," he instructed Aisha. "I want to see who lines up on both sides." Back in their apartment, Marcus and Janelle put the children to bed, trying to maintain normalcy despite the day's intensity. Isaiah had finally stopped asking when they would return to their old home, seeming to accept their new apartment. But Zoe remained more affected, quieter than her previously outgoing self. "Dad," she said as Marcus tucked her in, "I heard some kids at school talking about us. They said we're famous because we're fighting a rich man." Marcus sat on the edge of her bed, choosing his words carefully. "We're not fighting because he's rich, Zoe. We're fighting because what he did was wrong. Sometimes standing up for what's right gets attention." "Are we going to win?" The directness of her question caught him off guard. "I don't know," he answered honestly. "But I do know that we're not giving up, and that matters whether we win or lose." After Zoe had fallen asleep, Marcus found Janelle in their small living room, reviewing notes Professor Wilkins had sent home, potential questions the appeals court might ask if they were called to testify again. "Professor Wilkins thinks this could go all the way to the Supreme Court," Janelle said without looking up. "Our family's name could be in law books someday. Carter v. Whitmore." "Whitmore v. Carter," Marcus corrected gently. "They're the ones appealing. Either way," she said, finally meeting his eyes, "I never thought our fight for our home would become this." Marcus sat beside her, taking her hand. "Are you having second thoughts?" Janelle considered the question before shaking her head. "No, but I worry about the kids, about the attention, about what Whitmore might try next." She paused. "He went to their school, Marcus. What line won't he cross?" Before Marcus could answer, his phone buzzed with a text from Maya. "Major development. Meeting tomorrow morning, 8 a.m. Professor Wilkins says bring the whole family." As they prepared for bed, neither spoke the question weighing on both their minds. What new challenge awaited them tomorrow? Meanwhile, across town, Richard Whitmore met with his legal team in the private dining room of an exclusive club, raising glasses to what they believed would be an inevitable victory, one that would cement Whitmore's influence and set a national precedent limiting tenant protections for years to come. The next morning, the Carters arrived at the Civil Rights Clinic to find an atmosphere of controlled urgency. Law students hurried between offices carrying stacks of documents, while Professor Wilkins conferred intensely with two attorneys Marcus didn't recognize. Maya met them at the entrance, her usual composure replaced by barely contained excitement. "The appeals court issued their decision," she said without preamble, ushering them toward the conference room. "Only 9 days after arguments. It's almost unprecedented." "What did they decide?" Marcus asked, his stomach tightening with apprehension. Maya's expression confirmed his fears before she spoke. "They ruled 2-1 against us. Judges Clarkson and Mitchell found the city's eviction protections unconstitutional under the Takings Clause." "So we lost," Janelle said flatly, tightening her grip on Isaiah's hand. "We lost this round," Maya corrected. "But honestly, it's what we expected. And the dissent from Judge Hernandez was so strong, it gives us excellent grounds for appeal." Inside the conference room, Professor Wilkins introduced the unfamiliar attorneys as Daniel Cohen and Serena Washington from the National Housing Rights Association. "They'll be joining our team for the Supreme Court appeal," she explained, gesturing for everyone to sit. "Supreme Court?" Marcus repeated. "So we're definitely appealing?" "Already filed," Wilkins confirmed. "The petition for certiorari was submitted electronically at 6 a.m., 2 hours after the appeals court published their decision. "You prepared it in advance," Janelle observed. "Both versions," Wilkins nodded. "One in case we won, one in case we lost. The appeals court's rapid decision actually works in our favor. It underscores the urgency of the case and increases our chances of getting the Supreme Court to take it." While Maya took Zoe and Isaiah to a play area set up in an adjacent office, the adults discussed the implications of the ruling and next steps. Cohen, a veteran of multiple Supreme Court arguments, explained the timeline. "The court receives thousands of petitions each year, but hears only about 70 cases. Given the constitutional questions at stake and the circuit split, this creates, with other appeals courts that have upheld similar ordinances, we have a very strong case for certiorari." "What does that mean for our immediate situation?" Marcus asked. "The eviction itself?" "The appeals court stayed enforcement of their ruling for 30 days, Wilkins explained. "That means the city's ordinance remains in effect for now, and your current housing arrangement continues. But we need to prepare for every contingency." Serena Washington, who specialized in fair housing litigation, shifted the conversation to the discrimination aspects of the case. The appeals court barely addressed the racial discrimination claims, focusing instead on the constitutional question. That's actually an advantage for us at the Supreme Court level, where several justices have shown interest in addressing housing discrimination more directly. Including Justice Freeman, Cohen added. He authored the majority opinion in Rosewood Housing Authority versus Jenkins 3 years ago, which strengthened disparate impact claims under the Fair Housing Act. Professor Wilkins's phone buzzed with an incoming text. She glanced at it, then looked up with a grim smile. "Whitmore's giving a press conference right now, claiming vindication. His team is portraying this as a victory for property rights across the nation." "Let him," Cohen said confidently. "The more he frames this as a broad constitutional issue rather than about the Carters specifically, the stronger our case for Supreme Court review." The meeting continued for nearly 2 hours, covering legal strategy, media engagement, and personal preparations for the Carters. As they were wrapping up, Maya returned with the children, who had been happily occupied with law student volunteers. "One more thing before you go," Professor Wilkins said. "The national attention on this case is about to increase exponentially. We've arranged for a security consultation at your apartment this afternoon. Given Whitmore's previous actions, we want to ensure your family's safety." Outside the clinic, reporters had already gathered, apparently tipped off about the meeting. Marcus and Janelle shielded the children as Professor Wilkins made a brief statement, emphasizing their commitment to fighting the ruling all the way to the Supreme Court. This case is fundamentally about justice, not just for the Carter family, but for thousands of families across the country who face discriminatory eviction practices, she stated firmly. "We are confident the Supreme Court will recognize both the constitutional validity of these crucial protections and the underlying pattern of discrimination that necessitates them." The next few weeks brought a whirlwind of activity. The security consultation resulted in enhanced measures for the Carters' apartment, including cameras, upgraded locks, and direct lines to both campus security and local police. The children's schools were briefed on restricted visitor protocols, ensuring no one could access them without proper authorization. Meanwhile, the legal team expanded further as organizations across the country filed amicus briefs supporting their petition. Housing advocates, civil rights groups, and even several city governments weighed in, arguing that the appeals court decision threatened tenant protections nationwide. Whitmore's side garnered equally powerful support. Property owners' associations, developers' consortiums, and conservative legal foundations filed briefs backing the appeals court ruling. The case was rapidly becoming a flashpoint in broader debates about government regulation, property rights, and racial justice. 23 days after filing their petition, Maya called with news that sent Marcus's heart racing. "The Supreme Court has granted cert. They're taking our case." That evening, the expanded legal team gathered at the Carters' apartment to explain what would happen next. The court had expedited the case, scheduling oral arguments for just 6 weeks later, an unusually rapid timeline that reflected the urgency of the issues involved. Only Professor Wilkins and Mr. Cohen will actually speak before the court, Maya explained as they outlined the process. But they'll be representing your story, your experiences. That's why we need to prepare you for the increased attention. Indeed, within hours of the court's announcement, the media presence outside their apartment had doubled. News vans lined the street, and reporters approached them whenever they left the building. The children's school called to report that journalists had attempted to interview teachers about Zoe and Isaiah. "This is getting out of control," Janelle said that night after they'd finally gotten the children to sleep. Isaiah had awakened crying from a nightmare about the mean man coming to take their home again. "Professor Wilkins says it'll calm down in a few days," Marcus replied, though he shared her concern. "Once they've gotten their initial stories, they'll back off until the actual Supreme Court date." He was partially right. The immediate media frenzy subsided, but their case had become part of the national conversation. Op-eds debated the merits of their claim, television pundits analyzed the constitutional questions, and social media campaigns sprung up on both sides. Through it all, Richard Whitmore maintained a carefully crafted public persona, the reasonable businessman defending important principles. But his private actions told a different story. 3 of Marcus's former co-workers reported being approached by private investigators asking questions about his work history and character. Janelle discovered that someone had filed a complaint against her with the state nursing board, alleging negligence, a complaint quickly dismissed as baseless, but still added to her record. "He's trying to destroy our reputations," Marcus realized during a strategy session with Professor Wilkins, "creating a paper trail of complaints and investigations to discredit us before the Supreme Court." "Exactly," Wilkins agreed, "but these tactics actually help demonstrate the pattern of targeted harassment that forms part of our discrimination claim. We're documenting everything." In Washington, Justice Elijah Freeman had recused himself from the cert decision, given his personal connection to Professor Wilkins. But now that the court had taken the case, he would participate fully in the arguments and decision. As one of the court's strongest voices on civil rights issues, his involvement would be crucial. In his chambers, Freeman methodically reviewed the extensive briefing materials, paying particular attention to the evidence of racial discrimination that the appeals court had largely ignored. His clerk, Aisha, had compiled statistics on Whitmore's eviction patterns that painted a damning picture. "The disparities can't be explained by economic factors alone," Freeman murmured, studying the data. "There's clear evidence of targeting." Beyond the legal principles at stake, the justice found himself increasingly invested in the Carters' personal story. Perhaps it was because it echoed elements of his own family's history. His parents had faced similar discrimination in the 1960s, nearly losing their home to predatory practices before a community legal aid lawyer intervened. That lawyer had inspired Freeman's career choice, setting him on the path that eventually led to the Supreme Court. Now, decades later, he had the power to shape the law that would protect countless families facing similar struggles. As the argument date approached, the Carters worked with their legal team to prepare for every contingency. Marcus and Janelle wouldn't speak in court, but they would be present, visible representatives of the human stakes in this constitutional battle. "Remember," Professor Wilkins told them during their final preparation session, "whatever happens in that courtroom, you've already won an important victory. You stood up against injustice when many others couldn't. You've exposed discriminatory practices that might otherwise have continued unchallenged, and you've given hope to families across the country facing similar situations." The night before they were scheduled to fly to Washington, Marcus stood at the window of their apartment, watching the last news van finally leave for the evening. Tomorrow, they would travel to the nation's capital, The day after, they would sit in the highest court in the land, as 9 justices considered the legal principles that would determine not just their fate, but potentially the housing rights of millions of Americans for generations to come. "Are you ready?" Janelle asked softly, joining him at the window. "No," he answered honestly, "but we'll do it anyway." In his Georgetown home, Justice Freeman was also preparing, reviewing final notes, considering potential questions, and reflecting on the profound responsibility of the decision that lay ahead. A decision that would echo far beyond one family's fight against one landlord, potentially reshaping the landscape of housing rights and equal protection for decades to come. Washington, D.C. in early December was adorned with holiday decorations, the Capitol's monuments illuminated against the winter sky as the Carter's taxi made its way from Reagan National Airport to their hotel. The children pressed their faces against the windows, momentarily distracted from the gravity of their visit by the grandeur of the nation's capital. "Is that where the president lives?" Isaiah asked, pointing toward the White House as they passed. "Yes, buddy," Marcus answered, his voice betraying his own awe. 6 months ago, he had been a construction worker fighting to keep his family's modest rental home. Now they were in Washington, D.C., their case about to be heard by the Supreme Court of the United States. The hotel, paid for by a housing rights organization supporting their case, was more luxurious than anywhere they had ever stayed. 2 adjoining rooms had been reserved, one for the parents, one for the children, with a security detail stationed in the hallway. Professor Wilkins had insisted on the protection after Whitmore's escalating tactics of intimidation. "This doesn't feel real," Janelle whispered as they settled the children into their room, Zoe already exploring every drawer and closet while Isaiah bounced experimentally on the bed. "I know," Marcus agreed, "but tomorrow will be very real." A knock at the door announced Maya's arrival. She had flown in earlier to help with final preparations. "Professor Wilkins is waiting in the conference room downstairs," she informed them. "Last strategy session before tomorrow." After arranging for room service and a hotel staff member to watch the children, Marcus and Janelle joined their legal team in a small conference room off the lobby. Professor Wilkins sat with Cohen and Washington, surrounded by meticulously organized documents. "The court will hear 6 cases tomorrow, but ours is third on the docket," Wilkins explained. "Each side gets exactly 30 minutes. Mr. Cohen will handle the constitutional aspects, and I'll address the discrimination claims." "What should we expect?" Marcus asked, his mouth dry with anticipation. "Intense questioning," Cohen replied frankly. "This court doesn't sit passively. The justices will interrupt, challenge, and probe our arguments repeatedly. That's normal. It's how they test the legal principles at stake." Washington added, "They've received over 40 amicus briefs in this case, an extraordinary number that reflects its national importance. They've had time to form preliminary opinions, but oral arguments can still shift their thinking." "What about Justice Freeman?" Janelle asked. "Professor Wilkins, you know him personally. Will that help our case?" Wilkins chose her words carefully. "Justice Freeman will judge this case on its legal merits, not personal connections. That said, his jurisprudence has consistently recognized the reality of housing discrimination. We expect him to ask penetrating questions of both sides." The session continued for 2 hours, covering potential questions, media management, and courthouse logistics. By the time they returned to check on the children, Marcus felt simultaneously more prepared and more overwhelmed. "Dad, there's a swimming pool," Isaiah exclaimed as they entered, clearly having explored beyond their room despite instructions to stay put. "Can we go swimming after the court thing tomorrow?" The innocent question brought the reality of their situation into sharp focus. To their children, this was still partly an adventure, despite the circumstances that had brought them here. "We'll see, buddy," Marcus replied, exchanging a glance with Janelle. "We might be pretty busy tomorrow." That night, after the children finally succumbed to sleep despite their excitement, Marcus stood at the hotel window looking out at the illuminated Capitol dome in the distance. Janelle joined him, slipping her hand into his. "Whatever happens tomorrow," she said softly, "we did the right thing by fighting." "I know," he replied, though his voice betrayed his anxiety. "I just keep thinking about all the families who couldn't fight back, who didn't have Professor Wilkins or a civil rights clinic or national organizations backing them." "Then we have to win for them too," Janelle said simply. Morning arrived with a flurry of activity. The family dressed in their court attire, new clothes provided by supporters who understood the importance of appearances before the Supreme Court. Marcus wore a charcoal suit that accommodated his still-healing leg, Janelle a navy dress and jacket, and the children were dressed with similar care. Professor Wilkins met them in the lobby, her own appearance impeccable in a tailored black suit. "The media presence is significant," she warned. "We'll use the side entrance to minimize exposure, especially for the children." Even with these precautions, they couldn't avoid the crowd entirely. As their vehicles approached the Supreme Court building, they passed through a gauntlet of protesters and supporters holding signs. Housing advocates cheered when they recognized the Carter's car, while property rights supporters waved placards supporting Whitmore. "Eyes forward," Marcus instructed the children as they were escorted up the steps. "Just like we practiced." The Supreme Court building itself seemed designed to inspire awe. Massive columns, grand staircases, and the famous words, "Equal justice under law," carved above the entrance. Inside, the marble halls echoed with hushed voices as attorneys, journalists, and observers prepared for the day's proceedings. In a small conference room allocated for their use, they met briefly with the complete legal team for final instructions. The children would sit with Maya in the public gallery, while Marcus and Janelle would be directly behind their attorneys at the counsel table. "Remember," Wilkins told them, "the justices aren't looking at you during arguments, but your presence matters. You represent every family facing similar circumstances." At precisely 10 a.m., they entered the courtroom. The space was smaller than Marcus had imagined, but no less imposing. Rich mahogany furnishings, heavy burgundy drapes, and the elevated bench where 9 of the most powerful legal minds in the country would sit. The gallery was already packed with journalists, law students, and interested citizens. Across the aisle, Marcus spotted Richard Whitmore with his expanded legal team, the landlord's expression smug as he leaned toward Leonard Drake in conversation. At 10:15, the marshal called out the traditional "Oyez, oyez, oyez," announcing the entrance of the justices. The entire room rose as the 9 members of the Supreme Court filed in and took their seats. Marcus immediately identified Justice Freeman, a distinguished black man with close-cropped silver hair and intense, observant eyes. Though the justice's expression revealed nothing, Marcus felt an inexplicable sense of connection, as if Freeman somehow understood what this moment meant beyond the legal principles at stake. After the first 2 cases were heard, the marshal called Whitmore Properties versus Carter. As the attorneys moved forward, Marcus felt Janelle's hand tighten around his. This was it, the culmination of months of struggle, the moment when their private pain would be fully transformed into public precedent. Leonard Drake spoke first, his experienced voice confidently filling the chamber. "Mr. Chief Justice, and may it please the court, this case presents a straightforward question of constitutional law, whether a municipal ordinance that compels private property owners to provide housing without compensation constitutes a taking under the Fifth Amendment." He had barely completed his introduction when Justice Kagan interrupted. "Counsel, how is this different from long-established rent control ordinances that have been repeatedly upheld by this court?" Drake was prepared. "The critical distinction, Justice Kagan, is that rent control regulates the terms of voluntary landlord-tenant relationships. The ordinance at issue compels continued provision of housing services after the tenant has breached the fundamental term of the agreement, payment. Justice Alito followed with a question that revealed sympathy to Whitmore's position. Isn't the city effectively transferring the cost of public assistance from taxpayers generally to specific property owners? Precisely, Justice Alito, Drake agreed. That's the essence of our claim. Then Justice Freeman spoke, his deep voice measured but penetrating. Mr. Drake, your argument treats housing as merely another commodity. But this court has recognized in numerous decisions that housing occupies a special place in our legal tradition. Would you address the public health and safety rationales that traditionally justify greater regulation in this area? Drake's rhythm faltered slightly. Justice Freeman, while housing is indeed important, the Constitution still protects private property from uncompensated takings. The public health emergency doesn't eliminate that protection. If anything, it emphasizes that such costs should be borne by the public as a whole. And yet, Freeman continued, your client seems to have applied these principles selectively. The record indicates a striking disparity in how eviction proceedings were initiated against tenants of different races. How does that pattern affect our analysis? Drake's expression tightened almost imperceptibly. Those allegations are separate from the constitutional question before the court, Justice Freeman. The validity of the ordinance doesn't depend on how any individual landlord implemented it. For nearly 15 minutes, the justices pressed Drake on various aspects of Whitmore's argument. Some questions suggested sympathy, others skepticism. Throughout, Marcus observed Justice Freeman returning repeatedly to the discrimination aspects that the appeals court had minimized. When Drake's time expired, Professor Wilkins approached the podium. Her voice was clear and commanding as she began, Mr. Chief Justice, and may it please the court, this case is fundamentally about two inseparable issues: the constitutional authority of local governments to protect vulnerable residents during crises, and the persistent reality of housing discrimination that necessitates such protections. Chief Justice Roberts immediately challenged her. Counselor, aren't you conflating distinct legal questions? The constitutionality of the ordinance can be addressed without reaching the discrimination claims. With respect, Mr. Chief Justice, I disagree, Wilkins responded confidently. The court has consistently recognized that constitutional analyses must consider the real-world context in which laws operate. Here, that context includes both the public health emergency and the documented pattern of discriminatory enforcement. As the questioning of Professor Wilkins began in earnest, Marcus felt a curious mixture of pride and apprehension. Their family's painful experience had been transformed into abstract legal principles debated at the highest level. Yet somehow, in Wilkins's careful arguments and Justice Freeman's probing questions, the human reality of their struggle remained present. A reminder that beyond the constitutional theories and legal precedents, this case was still about real people fighting for their home, their dignity, and their right to equal treatment under the law. Professor Wilkins fielded the justices' questions with practiced precision, never losing her composure even as the conservative justices pressed her on the limits of government authority. Justice Thomas, usually silent during oral arguments, surprised everyone by asking a question that cut to the heart of the case. Professor Wilkins, if we accept your argument that the discrimination context is inseparable from the takings analysis, what limiting principle would prevent similar claims in virtually any regulatory context? The limiting principle, Justice Thomas, is evidence, Wilkins replied without hesitation. Here, we have documented patterns of disparate treatment. Black tenants evicted at 3 times the rate of white tenants with identical payment histories, internal communications using coded language to target specific neighborhoods, and explicit statements demonstrating animus. This isn't speculation about possible discrimination, it's direct evidence of intentional targeting. Justice Freeman followed up. Counsel, the appeals court largely sidestepped this evidence. In your view, how should this court weigh these findings in our constitutional analysis? Justice Freeman, this court has repeatedly held that facially neutral policies applied in a discriminatory manner raise equal protection concerns that cannot be divorced from other constitutional questions. The appeals court's failure to meaningfully engage with this evidence represents a significant legal error that this court should correct. Throughout the arguments, Marcus observed the justices' reactions. Justice Barrett seemed concerned about property rights, but troubled by the evidence of discrimination. Justice Kavanaugh appeared to be searching for a narrow ruling that might avoid setting broad precedent either way. Justice Sotomayor was clearly sympathetic to their position, while Justice Gorsuch's questions suggested skepticism about the city's authority. When Cohen took over to address specific constitutional questions, Justice Freeman asked a question that silenced the courtroom. "Counsel, beyond the legal theories, I'd like you to address the human cost. If we invalidate these protections, what happens to families like the Carters and thousands of others who relied on them during unprecedented hardship?" Cohen glanced briefly at Marcus and Janelle before responding. "Justice Freeman, that human cost is precisely why these protections exist and why they fall within traditional police powers. Without them, we face not just individual tragedies, but public health crises, educational disruptions for children forced to change schools, and community instability that affects everyone, not just those directly evicted." As the arguments concluded, Chief Justice Roberts thanked the attorneys. "The case is submitted," he announced, and with those 4 simple words, the formal proceedings ended. The justices filed out, leaving the parties to absorb what had just occurred. In the Supreme Court's private conference room later that day, the 9 justices gathered to take their preliminary vote. As the most junior justice, Barrett would speak last, while Roberts would lead the discussion. These initial conferences were famously private. No clerks, no recordings, just 9 individuals who would shape constitutional interpretation for generations. Justice Freeman listened carefully as his colleagues shared their initial impressions. The court appeared split along familiar ideological lines, with Roberts potentially serving as the swing vote. When Freeman's turn came, he spoke with measured conviction. "This case presents more than a narrow question about takings jurisprudence. It highlights the intersection of property rights, equal protection, and the reality of persistent housing discrimination. The evidence of racial targeting by Whitmore Properties is substantial and troubling. If we divorce that context from our constitutional analysis, we perpetuate a fiction that these legal principles operate in a vacuum, untouched by historical patterns of discrimination." Outside the court, the Carters faced a media gauntlet. Professor Wilkins had prepared a brief statement, which Marcus delivered with quiet dignity. "Today, our family stood before the highest court in the land to argue that housing discrimination is not just wrong, but unconstitutional. Whatever the court decides, we hope our case helps ensure that other families don't face the same injustice we experienced. This isn't just about one eviction or one landlord. It's about equal protection under the law for everyone." Across the plaza, Richard Whitmore offered his own statement to reporters, his voice smooth with practiced sincerity. "This case has never been about the Carters personally. It's about fundamental constitutional principles that protect all Americans' property rights. We're confident the Supreme Court will uphold these essential protections." That evening, the legal team gathered in Professor Wilkins's hotel suite to debrief. The mood was cautiously optimistic. Justice Freeman's questions were encouraging, Cohen noted, and Barrett seemed troubled by the discrimination evidence. "Roberts is the key," Wilkins replied. "He's concerned about setting broad precedent, but he's also an institutionalist who cares about the court's legitimacy on civil rights issues." Maya, who had stayed with the children during the arguments, reported that several law professors in attendance had been impressed by their presentation. "The consensus seems to be that the discrimination evidence strengthened our position considerably." Later, alone in their hotel room, Marcus and Janelle tried to process the day's events. "What happens now?" Janelle asked, removing her earrings with weary fingers. "We wait," Marcus replied. "Professor Wilkins says a decision could take months. And in the meantime, we just go back to our lives? After all this?" Marcus considered the question. Their lives had been irrevocably transformed. The small apartment provided through the housing network was secure for now, but the future remained uncertain. His leg was healing, but he still couldn't return to construction work. Janelle had reduced her hours at the hospital to manage the demands of the case and support the children through the upheaval. "I don't think we can go back," he said finally, "but maybe we can go forward." The next morning, before flying home, they took the children on an impromptu tour of the National Mall. Isaiah marveled at the towering Washington Monument, while Zoe stood solemnly before the Lincoln Memorial, reading the inscribed words of the Gettysburg Address. "Dad," she said, pointing to the famous phrase, "Government of the people, by the people, for the people. Is that what we were doing yesterday, being part of government?" The question caught Marcus off guard with its insight. "In a way, yes," he answered. "The law belongs to all of us, even when it doesn't seem that way." As winter deepened and the holidays approached, the Carters established new routines in their temporary home. Marcus began vocational rehabilitation, training for administrative work that wouldn't strain his injured leg. Janelle returned to full-time hours at the hospital. The children adapted to their new schools, though Zoe still occasionally asked when they could go home. The case remained in the national conversation. Law review articles analyzed the oral arguments, predicting possible outcomes. Housing advocates used the Carter family's story to push for stronger protections in other jurisdictions. Property rights groups countered with their own narratives about government overreach. 3 weeks after the hearing, Marcus received a phone call from Professor Wilkins. "Richard Whitmore has been indicted," she said without preamble. "Wire fraud, tax evasion, and conspiracy charges. The FBI has been investigating his business practices for years, apparently. Our case just brought extra scrutiny." The news reports revealed that Whitmore's empire had been built on fraudulent loan applications, tax schemes, and bribes to local officials. The discrimination evidence uncovered during the Carters case had led investigators to broader corruption patterns. "Does this affect our case before the Supreme Court?" Marcus asked. "Not directly," Wilkins explained. "The constitutional questions remain the same, but it certainly undermines Whitmore's public image as a respectable businessman simply defending property rights." In Washington, Justice Freeman reviewed draft opinions circulating among the justices. The court remained divided, with Freeman drafting what he hoped might become the majority opinion if he could convince Roberts to join. His clerk, Aisha, had compiled additional research on historical patterns of housing discrimination that strengthened their analysis. "Justice Freeman," she said, entering his chambers with a news clipping, "have you seen this? Whitmore's been indicted." Freeman read the article with interest but shook his head. "We decide the case on the record before us, not subsequent developments. Still," he added with the hint of a smile, "it does suggest our concerns about his practices were well-founded." As January turned to February, the Carters received unexpected news. Their former neighbor, Mrs. Henderson, had passed away, leaving Zoe and Isaiah her collection of children's books that brought me such joy when they would visit. The small kindness brought tears to Janelle's eyes, a reminder of the community they had lost. Meanwhile, Richard Whitmore's legal troubles mounted. Former employees came forward with additional evidence of discriminatory practices, including explicit instructions to find reasons to evict black tenants from upgrading neighborhoods. Several banks froze his assets pending investigation. The media narrative shifted dramatically. Outlets that had portrayed him as a principled defender of property rights now questioned how they had overlooked the signs of corruption. The Carter family, by contrast, received increasingly sympathetic coverage. highlighted as victims of both discrimination and a flawed system that had initially failed to protect them. One evening in late February, Professor Wilkins called with news that left Marcus momentarily speechless. "Whitmore's attorneys have approached us about settlement," she said. "They're offering substantial damages, immediate title to a property similar to your former home, and a consent decree regarding future rental practices." "Why now?" Marcus asked when he found his voice. "After everything they've put us through?" "His empire is crumbling," Wilkins explained. "The criminal charges, the asset freezes, the media exposure. He's trying to salvage what he can, and his attorneys likely suspect which way the Supreme Court is leaning." "If we settle," Janelle asked, having picked up the extension, "what happens to the constitutional questions, the precedent for other families?" It was the question that would determine their next step, whether their fight remained personal or had truly become something larger than themselves. Professor Wilkins arranged an emergency meeting at the clinic the following morning. The Carters sat across from the full legal team, the settlement offer printed in dense legal language before them. "To be clear," Cohen explained, "this offer would resolve your personal claims completely. The financial compensation is substantial, enough to purchase a home outright and establish college funds for the children. The consent decree would force Whitmore Properties to implement anti-discrimination training, change their eviction practices, and submit to independent monitoring for 5 years. But," Washington added, "if you accept, the Supreme Court case becomes moot. They'll dismiss it without issuing an opinion. The constitutional questions remain unresolved." Marcus and Janelle exchanged glances, communicating silently in the way long-married couples do. "What about the other families?" Marcus asked. "The ones who've faced similar discrimination but didn't have a legal team or national attention." "Without Supreme Court precedent, their path remains difficult," Wilkins acknowledged. "The circuit split continues. Some appeals courts upholding these protections, others striking them down. Future cases would have to work through the same lengthy process. And the settlement only binds Whitmore Properties," Maya added. "Other landlords could continue similar practices until challenged individually." Janelle leaned forward. "So we'd win, but the bigger fight would be—" She searched for the right word. "Deferred," Wilkins supplied. "Not abandoned, but postponed until another case reaches the court, which could take years. And there's no guarantee the next case would have such compelling evidence of discrimination," Cohen noted. "Or come before a court with this composition. Justices retire, administrations change, legal climates shift." The weight of the decision pressed heavily on Marcus. What had begun as a desperate fight to keep his family's home had evolved into something far larger. Now they faced an impossible choice: secure their family's future immediately or continue a legal battle that might help countless others, but could ultimately end in defeat. "Can we have some time?" he asked finally. "Not much," Wilkins cautioned. "They've given us 48 hours to respond. It's a tactical move. They know the court might be close to a decision." Outside the conference room, Marcus and Janelle found a quiet corner to talk privately. "It's enough money to buy a house," Janelle said, her voice low. "No more renting, no more landlords. The kids would have stability again." "I know," Marcus agreed. "But every time I think about taking it, I remember Isaiah's face when they put our things on the lawn. All those other families' children." He trailed off, unable to articulate the responsibility he felt. "We didn't ask to become symbols," Janelle reminded him. "We just wanted our home back. And now we can have a better one. But at what cost?" They spent the day in agonized deliberation, weighing personal needs against broader principles. That evening, they gathered the children in their small living room for a family meeting, something they'd done during previous difficult decisions. "We have a choice to make," Marcus explained, simplifying the situation for Isaiah's understanding. The man who made us leave our house has offered us money for a new house. So we'd win? Zoe asked, her 10-year-old mind grasping the essentials. In a way, Janelle said. We'd have a new home, maybe even better than the old one. But the bigger fight, to help other families like us, might not continue. Isaiah's brow furrowed in confusion. But what about the kids at my school? Darius said his family got evicted too. The innocent question struck Marcus like a physical blow. In the midst of their own struggle, he'd almost forgotten that Isaiah's new friend Darius had shared a similar story. Another black family evicted despite city protections, though without the resources to fight back. Zoe, always perceptive beyond her years, asked the question that had been haunting her parents. If we take the money, does it mean the mean man wins? No, sweetheart, Marcus assured her. He's in big trouble regardless. But it might mean other mean landlords could keep doing the same thing to other families. After putting the children to bed, Marcus and Janelle continued their discussion, going in circles until well past midnight. Finally, emotionally exhausted, they reached a decision. The next morning, they called Professor Wilkins. We can't take the settlement, Marcus told her, his voice steady despite a sleepless night. Not if it means the case disappears from the Supreme Court. There was a long pause before Wilkins responded. I want to be absolutely clear about what this means. You're turning down guaranteed compensation and housing security for the possibility of a favorable ruling that might help others, but could still go against you. We understand, Janelle confirmed. But we didn't come this far just for ourselves. We came for every family that's been through what we have, especially those without the resources to fight back. When Wilkins spoke again, her professional composure cracked slightly. In 25 years of civil rights work, I've rarely seen this level of courage. I'm proud to represent you. Within hours, news of the rejected settlement leaked to the press. Media reaction was immediate and polarized. Some outlets praised the Carters for their principled stand. Others questioned their judgment in rejecting financial security for their children. In Washington, Justice Freeman read the news with interest. While it couldn't officially influence the court's deliberations, the Carters' decision reinforced his sense that this case transcended ordinary constitutional disputes. In the privacy of his chambers, he redoubled his efforts to craft an opinion that might secure a majority. Meanwhile, Richard Whitmore's legal troubles multiplied. The FBI investigation expanded to include several local officials who had helped expedite his development projects. 2 former property managers came forward with detailed accounts of discriminatory practices, including written directives to find pretexts for evicting black tenants from gentrifying neighborhoods. As March arrived, the Carters settled into a strange limbo, their personal case more publicly visible than ever, yet their daily lives continuing in relative obscurity. Marcus started a new job in administrative support at a local community college. Janelle received a promotion at the hospital. The children's academic performance improved as the stability of their temporary housing continued. Then, on a Wednesday morning in late March, Maya called with news that sent Marcus's heart racing. The Supreme Court is issuing our decision tomorrow. That evening, the expanded legal team gathered at the Carters' apartment for final preparations. The mood was tense but determined as they discussed possible outcomes and media strategies. Based on the voting patterns and the time taken to issue the decision, we're cautiously optimistic, Cohen explained. If we'd lost 9-0 or 8-1, the opinion would likely have come faster. But we won't know until tomorrow, Washington cautioned. The court can always surprise us. Professor Wilkins addressed the practical concerns. Regardless of the outcome, there will be intense media interest. We'll handle the legal analysis and broader implications. Marcus and Janelle, you'll speak only to your personal experience. After the legal team departed, Marcus found himself unable to sleep. He stood at the window of their apartment, looking out at the city lights, thinking about the journey that had brought them here. From that rainy day when their belongings were thrown onto the lawn to the marble halls of the Supreme Court, it seemed almost unbelievable. Janelle joined him, wrapping her arms around his waist and resting her head against his shoulder. "Whatever happens tomorrow," she said softly, "we've already won something important." "What's that?" he asked. "Our dignity, our voice. No one can take those away again." In Georgetown, Justice Freeman worked late into the night, reviewing the final version of his opinion one last time before it would be released to the public. The case had evolved in complexity since oral arguments, with the justices engaging in multiple rounds of draft circulation and vigorous debate. What had begun as a seemingly straightforward conflict between property rights and government regulation had revealed deeper questions about equal protection, the lingering effects of historical discrimination, and the proper role of courts in addressing these persistent inequalities. Freeman closed the file, satisfied that the opinion reflected both sound constitutional analysis and a clear-eyed recognition of the realities faced by families like the Carters. Tomorrow, the nation would learn where the Supreme Court stood on these fundamental questions, whether the highest law of the land would acknowledge the intersection of property rights and racial justice, or treat them as separate and unrelated concerns. As dawn broke over both Washington and the Carters' hometown, millions of Americans went about their morning routines, unaware that a Supreme Court decision would be announced that might significantly affect housing rights nationwide. But in one modest apartment, a family that had refused to give up prepared to hear whether their principled stand had changed the legal landscape for generations to come. The Supreme Court's decision day arrived with a spring rain that reminded Marcus too vividly of the day they had been evicted. The family gathered around Janelle's tablet in their small living room, the SCOTUS blog website open to the live updates page. Professor Wilkins had offered to have them come to the clinic, but Marcus had insisted on privacy for this moment. Whatever the outcome, they would process it first as a family. "How will we know when it happens?" Zoe asked, fidgeting with nervous energy. "Professor Wilkins will call as soon as the decision is announced," Marcus explained. "The court releases opinions at 10 a.m. Eastern Time." At precisely 10:01, the tablet chimed with an update. "Opinions are being announced. First case, Whitmore Properties vs. Carter." Janelle's hand found Marcus's, gripping it tightly. "That's fast," she whispered. "They usually start with other cases." Before they could speculate further, Professor Wilkins's name flashed on Marcus's phone. His hand trembled slightly as he answered and put the call on speaker. "It's a 6-3 decision in our favor," she announced, her professional composure barely containing her excitement. Justice Freeman wrote the majority opinion, joined by Roberts, Kagan, Sotomayor, Breyer, and Barrett. The room erupted. Janelle burst into tears. Zoe jumped up and down, and even Isaiah, who understood only that they had won, joined the celebration. Marcus found himself momentarily speechless, overwhelmed by emotions too complex to name. "The opinion is remarkable," Wilkins continued. Freeman addressed both the takings claim and the discrimination evidence. The court held that temporary eviction moratoria during public health emergencies fall within traditional police powers and don't constitute takings requiring compensation. But more importantly, they explicitly recognized that housing discrimination claims cannot be separated from constitutional property analysis when there's evidence of disparate enforcement. "What does that mean in plain English?" Marcus asked, still processing. "It means the court not only upheld tenant protections, but also created new precedent for challenging discriminatory housing practices. The opinion specifically cites the statistical evidence of Whitmore's pattern of targeting black tenants and calls it a textbook example of how facially neutral policies can be weaponized to perpetuate historical patterns of housing discrimination." By afternoon, the full implications of the ruling became clear as legal analysts dissected Justice Freeman's carefully crafted opinion. The court had threaded a narrow constitutional needle, upholding the emergency eviction protections while establishing a robust framework for evaluating discrimination claims in housing contexts. Justice Freeman's majority opinion was being hailed as a landmark civil rights ruling, one that acknowledged the reality that property rights and equal protection couldn't be analyzed in separate constitutional silos. His opening paragraph set the tone. The Constitution's guarantees of property rights and equal protection are not competing values, but complementary assurances that all citizens may participate fully in the economic and social life of our nation. When evidence demonstrates that facially neutral property regulations are enforced in a manner that systematically disadvantages racial minorities, courts cannot analyze the constitutional questions in artificial isolation from one another. The dissent, authored by Justice Thomas and joined by Justices Alito and Gorsuch, argued that the majority had improperly expanded equal protection doctrine and undermined fundamental property rights. But it was Freeman's opinion that would shape housing law for generations to come. At a press conference held at the Civil Rights Clinic, Marcus and Janelle stood with their legal team to address the media. The room was packed with journalists, housing advocates, and law students eager to witness this historic moment. Today's Supreme Court ruling isn't just a victory for our family, Marcus stated, his voice steady and confident. A far cry from the desperate father who had pleaded with sheriff's deputies in the rain less than a year earlier. It's a victory for every family that has faced discrimination disguised as business decisions. It's a recognition that the law must see the reality of our experiences, not just the theory of equal treatment. Janelle added, "We lost our home, but we found our voice, and we're grateful that the highest court in the land heard that voice." Later that week, the family received an unexpected letter delivered by courier. The envelope bore the Supreme Court's official seal, and inside was a handwritten note from Justice Elijah Freeman. "Mr. and Mrs. Carter, though judicial ethics prevent me from communicating directly with parties to cases before the court, now that the decision has been issued, I wanted to express my personal admiration for your courage. When offered the certainty of personal gain, you chose instead to continue a fight that would benefit countless families you will never meet. In doing so, you exemplified the highest ideals of citizenship. Your children should be immensely proud of the example you have set. With respect and gratitude, Justice Elijah Freeman." Marcus framed the letter, hanging it in their living room, a reminder of how far they had come and the broader impact of their stand. The practical effects of the ruling unfolded rapidly. The city's eviction protections remained in place, shielding thousands of families still recovering from economic hardship. Housing rights organizations across the country filed new challenges to discriminatory practices, citing the Carter precedent. Law schools adjusted their constitutional law curricula to include the case as required reading. For Richard Whitmore, the Supreme Court defeat was merely the latest in a cascade of disasters. Federal prosecutors had expanded their investigation to include witness tampering related to the Carter case. Evidence emerged that he had attempted to bribe former tenants to provide false testimony about their experiences. His reputation in ruins, his assets frozen, and his criminal trial pending, Whitmore watched his empire crumble. In a final twist of justice, the federal judge overseeing the criminal case ordered the seizure of several Whitmore Properties holdings, including the very neighborhood where the Carters had lived. The properties were transferred to a community land trust dedicated to providing affordable housing, with preference given to families previously displaced by discriminatory practices. 3 months after the Supreme Court decision, Marcus stood with Janelle outside a modest 2-story home in a quiet neighborhood not far from their former rental. The house, purchased with funds from a housing justice organization's victorious settlement with Whitmore Properties Insurance Company, represented more than physical shelter. It was tangible proof that justice, however delayed, was still possible. "I still can't believe it's ours," Janelle said softly, as Isaiah and Zoe raced ahead to explore the backyard with its ancient oak tree perfect for climbing. Not just ours, Marcus corrected, thinking of the framed Supreme Court opinion that would hang alongside Justice Freeman's letter in their new living room. Everyone who comes after us will have a little more protection, a little more justice because of what happened here. Professor Wilkins, who had become a close friend through their shared journey, joined them for the housewarming celebration later that day. As evening fell, she raised a toast to the gathered friends, neighbors, and supporters who had stood with the Carters throughout their fight. To justice that may be slow, but refuses to be denied, she said, and to the courage of ordinary people who do extraordinary things when pushed beyond endurance. After the guests departed, Marcus sat alone on the back porch of their new home, watching Isaiah and Zoe chase fireflies in the gathering dusk. Janelle joined him, 2 mugs of tea in hand. "What are you thinking about?" she asked, settling beside him. "Justice Freeman's letter," Marcus replied. "The part about setting an example for the children." They watched as Zoe patiently showed Isaiah how to gently catch a firefly, cup it briefly in his hands to admire its glow, then release it back into the night. "I think they've learned the most important lesson," Janelle said, "that some things are worth fighting for, even when victory isn't guaranteed." Marcus nodded, his gaze taking in their new home, their playing children, and the woman who had stood beside him through it all. "And that justice isn't just a word carved on a building in Washington," he added. "It's something we have to make real every day, in how we live and what we're willing to stand for." In the gentle evening air, secure in the home that was now truly theirs, the Carter family had found more than shelter. They had discovered their own capacity for courage, the power of principled resistance, and the profound truth that sometimes, standing your ground, can change not just your own future, but the landscape of justice itself.